Good afternoon, everyone. My name is Jason Sitzman. I'm from the law firm of Shuttleworth and Ingersoll in Cedar Rapids. I'm also the chair of the IP section of the ISBA and your moderator for today's webinar. I'm pleased to have joining us today Jonathan Kennedy of the law firm of McKee, Voorhees, and Cease in Des Moines. Jonathan's technical training is in chemistry, and adding to his background is a master's degree in bioethics, where he focuses his research and writing on the ethics of technological regulations at the federal level. Jonathan practices in many areas of intellectual property law, including patents, trademarks, copyrights, trade secrets, and litigation and licensing. And his patent practice focuses on inventions related to chemistry and nanotechnology and material science. With that, I'd like to say we're pleased to have Jonathan with us here today, and with that, I will turn it over to our speaker.
Thank you very much, Jason. I appreciate that. To get started, I'll let you all know that this is recent developments in IP or in patent law, and recent developments is kind of a subjective term as to what you mean by recent. So we will be talking about some cases that are, we're waiting on published opinions still, but we have slip opinions from this year. And then we're going to backtrack to about 2014 for purposes of contrasting some other cases. But most of the cases should be pretty fresh, and if they've already received a lot of discussion in the IP realm, I may not touch on them for the areas that they're kind of well known for, depending on which case it is. And Jason will be taking questions. If you send in questions, you can get those to me. And what we'll do is we're going to hold those until the end of the presentation, and then I'll try to go through those questions with as much time as we have left. At the end, you can also email me questions if you have anything else you wanted to touch on, and we'll be providing a copy of the presentation shortly after the presentation is completed. So thank you very much for attending today, and I hope it's a beneficial CLE for you. So I'm going to start with a general outline of what we're going to talk about. We're going to talk about patent eligible subject matter, statutory bars, specifically the on-sale bar under the pre-AIA statute, and that has some implications as well for Section 102A1 of the AIA statute. Talk about indefiniteness, infringement, damages, patent trial and appeal board, and international patent protection. I know this is a lot of topics, and so we'll try to get through them as best we can, and hopefully it's good. So the cases we'll discuss on patent eligible subject matter are going to be Ariosa Diagnostics versus Sequenom, In Vitro Inc. versus CellzDirect, and we're noting that we're waiting on the Federal Circuit opinion for Cir.No versus Namco. It was heard in December, and we're looking forward to seeing that Federal Circuit opinion. That first thing when talking about patent eligible subject matter is to frame ourselves with the test that's currently being used by courts for the Alice and Mayo cases. It was originally provided in the Mayo case, Mayo v. Prometheus, by the Supreme Court, and then applied further in Alice. And it's a two-step test. And the first step is to ask whether the claim is directed to one of the patent ineligible concepts. So if you remember Section 101, that's abstract ideas, laws of nature, natural phenomena. The second step then is if you find that it is directed to one of the patent ineligible concepts, then you have to ask, or you have to search for an inventive concept. And this has been framed in a couple different ways, but one of the main ways is to say kind of searching for an inventive concept, looking to see if there's routine, conventional, known methodologies being applied, or if we're offering something new to the invention. So with Ariosa, the facts are that Sequenom is the assignee of the 540 patent, and that claimed a method for diagnosing certain fetal characteristics based on detection of maternally inherited cell-free fetal DNA. We won't read through the entire claim. We're going to point out some portions of the claim language, but I thought it'd be nice to have a copy of it in the presentation for later reference for you guys. So one of the issues is that prior techniques were a bit more risky, and the court actually, in its opinion, discusses a lot of the prior art, I think, to try to build a story of what was done before this and was this actually inventive? And so they talked about the prior techniques having risk as you take blood samples from the placenta or possibly the fetus, and so there was some risks associated with that. And some of those techniques have been around for quite a long time. So if you were thinking of secondary indicia of non-obviousness, you might consider whether there were long felt need or a problem that hadn't been solved. Obviously the secondary indicia don't apply to the 101 analysis, although it seems that the Patent Office, they do get confused pretty often with examiners and applicants alike, so that can be a tricky area. But there was some arguments regarding some of those, and I think the court just kind of put them in to make the record clear. So Ariosa Diagnosis sold the Harmony test, which was a non-invasive test that was used for testing certain fetal characteristics, including gender. That's a dominant one you can determine by the blood type or by some of the things in the CFF DNA, whether it was a male or a female fetus, and you didn't have to use these prior invasive techniques. So Sequenom sued Ariosa for infringement, and then Sequenom filed for preliminary injunction to enjoin Ariosa. And that's where procedurally we get this case. The district court denied the injunction, saying that there was a substantial question over whether the patent subject matter was eligible under 101. And we'll see here that Sequenom then appealed through an interlocutory appeal regarding the injunction. And on appeal, the Federal Circuit vacated and remanded the case for the district court to examine it and said you need to apply the Mayo test, or the association, excuse me, not the Mayo test, but the myriad genetics test, which was the test at the time. So the district court held that the CFF DNA was naturally occurring phenomena to which the claims did not add enough patent eligible. And they noted, this is important, that the only inventive component of the processes of the 540 patent is to apply those well understood routine processes to paternally inherited CFF DNA, which is a natural phenomenon. So Sequenom appealed and the Federal Circuit affirmed. And the Supreme Court denied certiorari. So it seems that they're sticking to the two-part test, and we'll talk a little bit more about the implications of that with the USPTO denying certiorari. So the first step, if we go back to our two-step test, is whether the claims are directed to patent ineligible concept. And here it's clear that there's the existence of CFF DNA in maternal blood is a natural phenomenon. The second step was the preparation and amplification of DNA sequences, and those are techniques that have been known and used for a while, that you can prepare and amplify certain sequences. And so the court actually said it was well understood, routine, conventional activities performed by doctors as early as 1997. And so the holding was that it was patent ineligible. The next case we'll discuss is rapid litigation management versus CellzDirect. And at the end of these, we'll discuss some contrasting of what these opinions mean in light of each other. In vitro is the assignee of the 929 patent, which is directed to a method for multiple freeze-thaw cycles for cells and for liver cells. And previously, it was pretty well understood that, or accepted, that you could only freeze and thaw these cells one time. And the inventors here discovered that there was a percentage of the cells that would survive refreezing and rethawing. And so they found a way of identifying those cells and isolating them and separating them. So the claims here, again, is the claim 1 as an example. Here's the important parts. It's a method of producing desired preparation of multi-cryopreserved pepticytes being capable of being frozen and thawed at least 2 times, and then subjecting the hepatocytes to density gradient fractionation to separate them, recovering those, and then cryopreserving those again. So those are the basic things that we're going to look at in the test, and the basic things that the court looked at when they applied the two-part Mayo-Alice test. And again, the court here built in a story talking quite a bit about the history of liver cell freezing and thawing, and talked about the issues that were brought up by having cells that can only be frozen one time and thawed one time, the expense that created, the lack of products available on the market just because you couldn't refreeze the cells. So there were some issues, and the fact that prevailing wisdom, as they said, was that the hepatocyte cells could be frozen only once, and then they either had to be used or discarded. And so this was a pretty monumental find for these inventors, as the court would kind of frame it. So again, the procedural history here is that In Vitro brought an infringement suit against CellzDirect. And actually, I put in vitro. I should note this because it says rapid litigation management. There's actually, during the course of this litigation, there was a number of transfers of assets and assignees to the various IP rights, and then also some of the companies that were involved. So In Vitro was the main company who was competing against CellzDirect, but rapid litigation management ultimately ended up subsuming that. If you look at the actual case name, I think there's 3 plaintiff parties listed and 2 or 3 defendants listed as well. So the district judge granted CellzDirect's motion for summary judgment based on the Mayo and Alice decisions, applied the 2-part test, and said this is not a patent eligible invention. So the first step was that the hepatocytes are capable of surviving multiple freeze-thaw cycles. And they said that this is a law of nature. The fact that cells were capable of doing that is something that the inventors didn't change. They didn't modify the cells in a way to make them capable of it, but it's just a natural property of the cells. It was the fact that someone hadn't identified that a certain portion of those cells would be viable after refreezing and rethawing. Then they looked at the second step and they said, so are we applying well-known or conventional routine methods? And the first thing was to subject it to density gradient fractionation to separate. And that was a well-known technique for separating cells. After that, they recover them and cryopreserve them. Again, well-known techniques. And I mean, these are techniques that have existed, obviously, in the prior art, in that these cells were already being recovered and cryopreserved one time. In Vitro appealed the district court's ruling. And the Federal Circuit, well, I guess I brought these up again here. We can move past these because we kind of discussed those, sorry. So the Federal Circuit applied an analysis here, and we'll jump down to the third bullet under the second step. Or actually the first step here. So the Federal Circuit first made a statement that a patent directed to a law of nature is not automatically invalid. I think that gives everybody who's a patent attorney or an inventor in this area a little sigh of relief. To say, okay, even though we've had a lot of cases that have made it very difficult, and prosecution is really difficult right now, theoretically, something directed to a law of nature is not automatically invalid. I think this Federal Circuit's tried to do that a few times, or rein in some of these rulings and find patentable subject matter, and every time they do that, though, the Supreme Court comes back and says, no, we like the tests we've given you, so please apply those. No bright line test here. But anyway, the Federal Circuit went on then to say the use of conventional methods in an unconventional manner can be enough to create an inventive concept. So there's some guidance there potentially for practitioners as well. And then the Federal Circuit said the method contained an inventive concept because the science of cryogenics previously limited liver cells to a single freeze-thaw cycle. So even though the inventors discovered a natural phenomenon, the court held that the fact that it was outside of conventional wisdom and was really unknown, and what they were doing was arguably applying some techniques. There's still a law of nature that certain cells are capable of refreezing multiple times and thawing multiple times, but identifying those and then selecting those and finding a way to amplify those, or recover just those, the court decided was something that was patent eligible. And we'll see what happens to this if the Supreme Court picks it up or not. So kind of contrasting Sequenom and CellzDirect, we can, as I mentioned earlier, the denial of Sequenom's petition seems to provide some strength to the Alice-Mayo framework, and that's the court ultimately applied that, and the Supreme Court denied certiorari. But the Federal Circuit's decision in CellzDirect seems to create some tension with that, in that it does seem to run a little bit against the Alice-Mayo test in a strict sense. If you go back to the district court's ruling in the CellzDirect case, you apply the two-part test. Is this directed to a natural phenomenon or a law of nature? There's an argument that it is. The cells themselves are capable of being refrozen for a second time and rethawed. And then you go back to the second part of the test and say, what else is being done there, search for an inventive concept, and we're using routine, separation techniques, recovery techniques, and then refreezing or, cryopreservation techniques. So there does seem to be some tension there, but the Federal Circuit has decided that it's patent eligible for the time being. So as of now, it's unclear whether CellzDirect is going to carve out an exception to the Mayo framework or not, and we'll see if the Supreme Court picks it up. So that's something to kind of keep an eye on. Next case we'll talk about is MCRO versus NAMCO. And this is the case I mentioned earlier was previously heard. There's a district court ruling, and you can see the citation to that there. And then the Federal Circuit picked it up, and there's the appeal number. And they heard oral arguments in December, and so we're waiting on an opinion. So the facts and litigation history here. MCRO holds 2 patents directed to lip synchronization in video games. And they filed infringement suits against 16 different game developers. The defendants moved for summary judgment, asserting that actually there was some 12B motions, because they filed an identical complaint. So this is kind of practice pointer here again. They filed an identical complaint against all 16 defendants, and the court ruled on the 12B6 motion, saying that they hadn't stated a claim that relief could be granted upon with respect to each of the 16 defendants, because it was basically identical except for a word search of the defendants' names and their products, but it didn't apply any kind of argument or rationale regarding why those different video games infringed or how they infringed. So when the court provided the 12B6 ruling, they did provide an opportunity for MCRO to amend their complaint or their complaints, and they did do that. They amended them, and ultimately the game developers then moved under Section 101 for summary judgment, saying that it's ineligible subject matter, and the district court held that the claims were invalid. This is an interesting test because the judge actually decided not to follow the Mayo test. So what the judge did here was said that on their face the claims are directed to an abstract idea, and then the court said let's look at the tangible aspects of the game. So in that sense, when you first look at it, it does seem to partially apply the Mayo test. It says, is this directed to an ineligible concept? And the conclusion was yes, an abstract idea. But then rather than applying the second part of the step and asking, is there anything here that's beyond the the routine conventional wisdom in the area or what's known, the court actually just looked at the tangible aspects of the claims and contrasted those with the prior art to say, do those exist in the prior art? And what the court did was this stripping approach is what's being called, and it stripped out all those elements and then came back and said, after looking at what was left, very few elements were left beyond the abstract idea, and thus the district court held it was invalid. So, as I mentioned, that case was appealed to the Federal Circuit, and we're waiting on the opinion. Next case to discuss is the statutory bars. Actually, I might step back just one more point there, say that, while we're waiting for that opinion, it might be interesting to see whether the Federal Circuit, remands saying strictly apply the Mayo test, or if they actually kind of look at this and treat it as an application of the Mayo test, because as I mentioned, the first step seems to be met, and really the second step, this stripping away, is almost like an inverse of the second step, where you say, is there anything more? And in a sense, the judge did come to the conclusion that there was nothing more other than what was already known in the prior art. So it seems like an inverse approach to it, in the sense that rather than looking at the different elements, the judge just took them, kind of cut them out of the claim. I picture the judge just having like a red line through the claim and then looking at what was left. So anyway, this is a recent case that came down dealing with statutory bars, in particular the on-sale bar under the pre-AIA 102 statute. And as I mentioned earlier, this has implications for the new AIA, or for the AIA statute 102A1, is the language and the limitations there regarding the sale bar are pretty similar with respect to that section. So this one actually came down yesterday, and I'll give you a little brief summary of the facts. So the case centered around a blood thinner, Angiomax, and that's the chemical name there, bivalirudin. And the Medco, we'll call them Medco, owns the drug rights to Angiomax. And they have two different patents, and the patents are the 727 patent, which is directed to the compound, and the issue with the development of Angiomax is that there is something called, or it's designated ASP9, and if ASP9 is in too high of a concentration, then the drug's not safe and they can't use it. But they were trying to identify a way to get to the maximum level of ASP9 that was safe and it could be used in the drugs. So the compound here is specific to having this certain level of ASP9. And similarly, they have a patent, the 343 patent, that's directed to this process of preparing the compound with that level of ASP9. And Hospira filed two abbreviated new drug applications for approval to sell generic bivalirudin on the market prior to the patent term ending. And in response, well, we'll keep going through here. So actually, we'll keep going through the facts and then we'll get back into the procedural history here. So Medco, this is pretty pertinent to the on-sale bar. Medco doesn't actually have manufacturing capabilities. They source out all their manufacturing to third parties. And one of the companies that they've been working with for a long time is this Benvenue. And they've actually been having Benvenue manufacture Angiomax, and it's the predecessor formulation for Angiomax since 1997. And as I mentioned just a minute ago, the ASP9 and the patents are directed to this new formulation. So the high levels of ASP9 that are still safe are part of the patents and that process. Beforehand, Medco had Angiomax, and it was lower amounts of ASP9, but they had some problems in the manufacturing with Benvenue specifically and had to put it on hold multiple times to try to figure out some problems they were having with manufacturing. And as a result of that, Medco actually developed the new formulation in this way, this new process, so that they could get this these patents on this high level of ASP9 that's not at the maximum level of danger here. So they've been working with Benvenue though since 1997 and since 2006 on the new patents. And in 2006, after they developed this new method, they wanted to test the method. So they used their contract and paid Benvenue to prepare 3 batches that would be commercially viable batches. You know, obviously, if they're testing them, they're not actually going into a patient population for testing, but they are just testing the procedure, making sure that they weren't having the same problems that they had before. So this is the subject of the patents, this new method. And the 3 batches were then placed on hold until all the testing was successfully completed. And obviously, they didn't want to deal with selling them and risking on sale bar. So the batches were quarantined pending FDA approval. And then the court talks a lot about the critical date, which is the 1 year prior to the filing of the patents, if you read the case at all. And the batches remain quarantined until at least after the statutory bar critical date of July 27, 2007. At the same time, they're also working on getting a distribution agreement in place at that same time. So back to the litigation and the procedural history here. Hospira challenged the validity of the patents under Section 102, saying that there's a prior sale. Specifically that Medco's contracting with Benvenue and paying Benvenue to manufacture the drug was a commercial sale of the IP, and that those things occurred prior to the 1 year, you know, prior to the critical date. We'll say it that way, prior to the critical date. So the court, the district court, applied a 2-part test from PAF and said that you know, was the claimed invention the subject of a commercial offer for sale, and was it ready for patenting? And the judicial opinion, and I will also address the second question first, and they came to the conclusion that it was ready for patenting, essentially, that at the stage that Benvenue was now being asked to manufacture the drug, they had already conceived of this new process and the new compounds and had reduced it to practice sufficiently that they they were outside of their development area and actually asking a manufacturer to try to produce it to make sure that it actually, that it worked. So there's a little bit of an argument maybe that process is still a little bit of an experimental process, but the court concluded that having Ben Venue do it was actually a demonstrated reduction to practice. So the next question was whether the claimed invention was subject of a commercial offer for sale. And the court found that it was not offered for sale. Hospira appealed, and the appeal was looking at whether the circumstances of Medco hiring a third-party manufacturer to manufacture the drug constituted a commercial sale despite the absence of transfer of title. And that's because the entire time Medco was still owner of the drug. They hadn't actually at that point sold it to their distributor, for their distributor then sell to stores or to patients, or whatever avenues they would take, pharmacies. So then there was another question of whether the court should overrule or revise the special devices principle, that there's no supplier exception to the on-sale bar of 102B. And that's an older doctrine regarding the ordering of, special devices, or, devices that are part of an invention, and, whether that would violate the on-sale bar of getting those components or getting, your entire invention purchased from a supplier. And so there's the issue again on appeal, and the holding at the Federal Circuit was that it was not a commercial sale. And the rationale is that the mere sale of manufacturing services by a contract manufacturer to an inventor to create embodiments of a patented product for the inventor does not constitute a commercial sale of the invention. They noted that stockpiling by the purchaser of manufacturing service doesn't constitute commercialization. So if you manufacture a large quantity of things so you can get ready to go to market, you actually haven't sold those things. And I think they're thinking similarly, somebody who doesn't have in-house manufacturing capabilities but is retaining ownership shouldn't be under that pressure. And there's commercial benefit even to both parties, or the commercial benefit even to both parties wasn't enough to trigger the on-sale bar. And I think the case speaks to how much Ben Venue was paid for those 3 batches. It was over $300,000. So that's where the commercial benefit argument comes in. So, and the Federal Circuit then said that the transaction must be one in which the product is on sale in the sense that it's commercially marketed. It's available to sell to pharmacies. It's available to, get distribution to patients, end users, right? Hospitals, that kind of thing. So, this is again noting that due to the similarities of Section 102B and the new 102A1, it doesn't explicitly apply. The court didn't make any statements that it would apply, but the argument is that it should apply as well to that, or this rationale should apply to the new AIA statute. So we get into the indefiniteness cases. First look at Teva. Teva owned the 808 patent pertaining to the manufacture of a multiple sclerosis drug. Sandoz attempted to manufacture a generic version of the drug, and Teva filed for infringement. In defense, Sandoz argued that the patent was invalid under 112 as indefinite. They had other grounds as well, but since we're talking about indefiniteness, we'll focus on indefiniteness. And the main part of the claim language that they were looking at is this molecular weight of about 5 to 9 kilodaltons. And this is a case, for people like myself who practice in the chemical area. It's like, whoa, wait a second, molecular weight, and talking about indefiniteness, it seems like that shouldn't be. You can see molecular, the atomic weights of elements on the periodic table, and obviously with polymers are much different in their molecular weights and the range of molecular weights that any particular specific polymer can have that somebody's trying to manufacture or use. But definitely it was like, oh, red lights, you gotta take a look at this case when it came down. So there were 3 methods of measuring the molecular weight. One is the peak average, one is the number average, and one is the weight average. And it was clear in the record, both parties agreed that if you use any of these methods, they would come to a slightly different result. And the claims, importantly, did not specify which method to use. So the issues that actually went on appeal to the Federal Circuit was the standard of review for patent claim construction and whether that was clear error due to findings of fact in the record or whether it was de novo. And then the second issue was whether the term molecular weight was indefinite as shown in the claims and is embodied, reflected in the patent specification, or read and light in the specification. So the case ended up getting appealed as well to the Supreme Court, and at the Supreme Court they addressed the standard of review and said that the skilled artisan inquiry in claim construction more closely resembles determinations categorized as conclusions of law. And so they ended up going with a de novo review, and that seems consistent with the idea that Markman, in characterization or interpretation of the claim language and certain claim elements is also considered to be a matter of law, that you have a Markman hearing and the judge assigns the meaning to the claims. So not too surprising there, but there were some findings of fact that influenced that, that decision, or the prior ruling dealing with the expert witness testimony regarding the molecular weights and what the term means in the art. So then the Supreme Court remanded to the Federal Circuit to deal with whether or not indefiniteness or molecular weight was indefinite under the Nautilus standard. So as you know, the prior standard was whether a claim was insolubly ambiguous, but in Nautilus a couple years back, the Supreme Court looked to the public notice function of patent claims and said that we need to have reasonable certainty so that people know how to craft around patents so that they're not infringing, and also how to use what's available in the public space. And the Federal Circuit held that the claim was indefinite. Here's some of the reasons that they did. So the patent provides no express definition of the molecular weight term. So there's no, as used herein, the term molecular weight shall mean, etc. None of that. They just use the term molecular weight. They found that the prosecution history did not clarify. And part of what was difficult there is that there was actually multiple patents that issued with a near identical specification. And they'd actually faced an indefiniteness challenge in some of the prosecution. And in one of the cases, the patent that was on here, appeal here, they argued that one of the particular methods, I forget which method it was, but say the MP method, the peak molecular weight, was the way that the claims were supposed to be read. And then actually in one of the other applications, they said that it was a different method. And so I think that was pretty difficult on them, in having a consistent prosecution history. And that's, again, another practice pointer, people working in the area of patent prosecution, as you develop applications looking back to prosecution history of other applications to make sure that you're not doing anything that's undermining your prior patent application or your current one, making sure that you have consistent arguments regarding claim terms and rejections that are the same or similar. And so as a result of these things, the court found that the claim scope lacked reasonable certainty, and it was held invalid. Next one I want to talk about is Dow Chemical Company versus Nova. And finally, we're getting away from some words. I've got a little bit of a timeline here. So here we go. Dow sued Nova for infringement of the 053 patent and the 023 patent, and Nova counterclaimed for invalidity. And one of the grounds that Nova counterclaimed on was indefiniteness. So the jury found for Dow and found the patent was not invalid, and found the both patents were not invalid and the patents were infringed. Nova appealed. The Federal Circuit affirmed the jury findings. And there was, in the meantime, Nova then sought certiorari, and cert was denied by the Supreme Court. So after all this time had gone on, Dow said, hey, we need supplemental damages. We're losing patent term here as we're going through all these appeals. So Dow sought a bench trial to have supplemental damages regarding their lost profits and any reasonable royalty they're entitled to, and also enhanced damages. And they won them with respect to the lost profits and with respect to the reasonable royalty. But the court denied their motion for enhanced damages. So Nova then appealed the damage award, and Dow cross-appealed. So Nova said, no, the damage award on the supplemental damages is improper, and Dow said we should have been entitled to the enhanced damages. So this is the big issue here. In the meantime, Nautilus is decided. So originally, when the jury found that the claims were valid, they were applying the insolubly ambiguous test. But because this case continued to go on for a while, Nautilus came down and the reasonable certainty test came about. And the pertinent claim language here is the slope of strain hardening coefficient. And this is a slope that this was in the opinion and one that they use as an example. And so it requires measuring the maximum slope. And there's a point where you have to measure the maximum slope in order to obtain the slope of strain hardening coefficient, which was recited in the claims. And similar to the TIVA case, there are 3 methods of measuring the maximum slope, just like there were 3 methods of measuring the molecular weight. There's the 10% secant tangent method, the final slope method, and the most linear method. Each method, again, produced different results, and that was agreed upon by the parties. So the Federal Circuit said the question is whether the existence of multiple methods leading to different results without guidance in the patent or the prosecution history as to which the method should be used renders the claims indefinite. And we think back to the TIVA case, they analyzed the prosecution history as they should and found that there were inconsistencies between 2 near identical specifications, and that was pretty detrimental to them. And I think had they only had one of those where they had dealt with the indefiniteness rejection from the examiner and said it's the peak molecular weight, that the case could have had a completely different outcome. And definitely if they applied the same in both, it could have also had a different outcome. So here again, the court's saying we need to look to the claims and then also to the specification and the prosecution history. And they noted again that Nautilus is really emphasizing the public notice function. It's not whether a claim is insolubly ambiguous, somebody can maybe figure out a way to read it, but really whether does it provide reasonable certainty so that businesses can carry on and make informed decisions. And the result here was that it was indefinite, not too surprising in light of our discussion of the TIVA case. So those 2 cases both applied indefiniteness to something where there were multiple reasonable interpretations. And so I think that's one of the categories we have to think about right now with current case law as we're applying the Nautilus case is when you're using a term and it has multiple reasonable interpretations, what are you going to do to keep your claims definite? And we'll address some practical pointers here in a few moments. But I want to talk about a couple other cases dealing with some other types of terms. So the first is DDR Holdings, talking about subjective terms. And DDR Holdings is a 2014 case, one of the older cases we're discussing for our recent developments, CLE here. And you may have heard of DDR Holdings because it is one of the only cases, if not the only case, I'm not sure, I don't keep up completely in the computer software area. We have plenty of attorneys at our firm who do and are excellent at that, but I focus most of my work in chemistry. But DDR Holdings, I know, is one of the only cases that applied the Alice test in a computer software environment, and the claims were held to be valid. And for a long time, at least, it was the only case. I'm not sure if another case has come down. So that's what it's pretty famous for, but we're going to look at it for this subjective term and indefiniteness. So there are 2 patents here, the 572 and the 399, and the term at issue was the look and feel. And it's a subjective term, what's the look and feel of that? Might say that about a car or something, I'm not sure. So capturing a look and feel description associated with a host website and storing HTML code corresponding to the look and feel description at a second website. So that's how it's used in the claims. And the court said the term had an established meaning in the art by the relevant time frame. And so they looked, obviously to the extrinsic record of it. They looked at the specification in this case. They looked at the claims. They found that it was used consistently in the specification. But they also looked at some extrinsic evidence to say, is this a term that one skilled in the art would understand? And they found that it was kind of a term of art in this field, in the scientific field. And so as a result, they found that it was definite. Terms of degree, so instead of subjective terms, terms of degree. We'll look at interval licensing. This is another one of the cases from 2014. And there are two patents at issue here, 652 and the 399 patent. And the term was unobtrusive manner, and this is the quote from the claim language, in an unobtrusive manner that does not distract a user. So that's how the term is being used. And you can see there it's a term of degree. How much is in an unobtrusive manner? Obviously, it's not an obtrusive manner, but there's definitely varying term of degree here. And the court said a term of degree like unobtrusive manner fails to provide sufficient notice of its scope if it depends on the unpredictable vagaries of any one person's opinion. And as a result, it was indefinite. And this is interesting to note. They said, we do not understand the Supreme Court to have implied in Nautilus, and we do not hold today, that terms of degree are inherently indefinite. Claim language employing terms of degree has long been found definite where it provided enough certainty to one of skill in the art when read in context of the invention. So they wanted to temper their holding, saying, let's not have this understood that all terms of degree are indefinite. They can be definite, but in this instance it wasn't. So the takeaway from these cases is with multiple reasonable interpretations, you need to specify the interpretation clearly in the specification and/or claims. And you'll find that in a lot of instances these days, it's being put into the claims. So if we say you'd have, the copolymer 1 has a molecular weight between 5 and 9 kilodaltons, as the claim said in the Teva case, then you say based on the peak molecular weight measuring method, and that's how you want to do it in the claims. With subjective terms, the question is, does it have an established meaning in the art? And you're probably benefited by putting all these things into a definition section. And if you want to be able to put into a definition section something that has multiple reasonable interpretations, like say, the molecular weight can be calculated by any of these means, you can do that, but you just need to specify which ones. And maybe that you can have within your range you can actually achieve using 3 different ways and say that, or the average of those, or whatever it is. You just need to be clear and work with your inventors on that, what the proper way to do it is, or what way they're doing it, and probably what way your data is doing it, so that you can consistently argue your data in support of your interpretation. But yeah, with subjective terms, it's probably good to have a definition if you can, but at least know that the term has meaning in the art. But I would recommend putting it in your specification, what the meaning is. You don't want to be dealing with the extrinsic record after the patent's been held invalid. So terms of degree, not ipso facto indefinite, but we do want to look at the specification, prosecution history, and knowledge in the art. So again, you might be pretty well benefited under the new standard to put definitions in, at least shaping some boundaries and some scope there. All right, on to infringement. Limelight versus Akamai. Akamai was an exclusive licensee of a patent claiming a method for content delivery network that allowed users to store certain information, and they did this by tagging those things. Limelight also operated a CDN, carried out several steps of the patent at issue, but users did their own tagging. So in the prior one, in Akamai, I misspoke there, the users didn't do the tagging, but there was a software mechanism that did tagging. And in the Limelight scenario, the users were required to do their own tagging. So Akamai filed an infringement suit against Limelight. And the issue was whether a party may be liable for infringement where 2 or more entities together perform all the steps of a process or claim. And here, the argument is that Limelight provides the software and everything that you need, and they're shifting the tagging process or portion of the claims onto the users. So doing that together is their infringement. In the pertinent statutory section, we'll focus on Part B because subsection A is just infringement. Whoever actively induces infringement of a patent shall be liable as an infringer. So the Supreme Court said indirect infringement must be predicated upon direct infringement. And where all the claim steps in a method cannot be attributed to a single entity, direct infringement has not occurred, and a party can't be held liable for indirect infringement. There's a big case. I mean, everybody's probably familiar with this, so I won't spend a lot of time on it. We'll kind of move through it. But the analysis on remand at the Federal Circuit was whether it was attributed to a single entity, and they held that directing or controlling another's performance would satisfy that. And in this instance, they found that it was that Limelight directed and controlled the users so that they had the tagging. They were supposed to do the tagging. They were directed to do the tagging. It was kind of controlled by Limelight in the environment that they set it up. So they did find that it was attributable to Limelight, and Limelight was liable. So liability for direct infringement occurs when a party performs all the steps of a method themselves, acts through an agent, contracts with another entity to perform one or more of the steps, so you have an actual contract there, or, as in this case, controls or directs another entity's performance. Participants of a joint enterprise, this is important because they analyze whether or not the parties could be a joint enterprise even if they're distinct parties. Participants of a joint enterprise can be liable for direct infringement based on acts of each other. And the joint enterprise is characterized by an agreement, whether express or implied, a common purpose, a community of pecuniary interest in that purpose, and an equal say, equal control in the direction of the enterprise. And notably, that's an and at the end of that list, whereas the list regarding when a party was inducing infringement was an or. It could be through control or direction or somebody doing it themselves, whereas here, to have a joint enterprise, you need all of these elements. Next case to talk about with respect to infringement is Camille USA versus Cisco. And Camille owns a patent for a method of supporting short-range wireless networks. And they filed an infringement suit against Cisco, arguing that Cisco directly infringed by performing the method, and also that it induced its customers to infringe. In its defense, Cisco argued that it could not induce infringement because it had a good faith belief that the patent was invalid. And so they said, we're not infringing because we all along didn't think the patent was invalid. So the issue here on appeal was whether a defendant's belief regarding patent validity can be a defense to a claim of induced infringement. And the holding was, this is an important holding, is that a good faith belief in a patent's invalidity is not a defense to inducement, as validity and infringement are separate and distinct issues. The threshold for inducement is met where the defendant knows of the patent and the induced acts constitute infringement. So a good faith belief of patent invalidity does not negate the mens rea requirement for infringement. And the court noted that allowing this new defense would also undermine presumption that is a common core of thought and truth reflected in the court's precedents. Under the Patent Act, a patent is presumed valid. I think that really speaks to this. A patent is presumed valid, so even if a party says, I really don't think it's valid, that doesn't mean that you can use that necessarily as a defense to inducement of infringement. You can obviously assert invalidity as a defense in your case, but it wasn't going to effectively stop the claim for induced infringement or relieve them of liability from that. So with respect to damages, there's the Stryker versus Zimmerman case and the Halo Electronics versus Pulse Electronics, which were consolidated for purposes of an appeal and were brought together. And then the Apple-Samsung case. The facts and litigation history for the Stryker and Halo cases. In both Stryker and Halo, the jury found willful infringement at trial. The Federal Circuit applied the Seagate test and denied treble damages in both cases. And again, the Seagate test is that you need to prove by clear and convincing evidence that the infringer acted despite an objectively high likelihood. This is the objectively reckless standard, objective recklessness standard. So the infringer acted despite an objectively high likelihood that its actions constituted an infringement of a valid patent, and that this objectively defined risk was either known or so obvious that it should have been known to the accused infringer. And the issue that went up on appeal to the Supreme Court was whether the Seagate test is consistent with the statute regarding enhanced damages. And the court held that the Seagate test was ineffective because the requirement of objective recklessness allows for the most willful infringers to avoid enhanced damages. Because even if they intended to do it, it doesn't necessarily mean that it was objectively reckless, right? And they also said that the clear and convincing standard shouldn't be applied, as the standard, most patent litigation damage issues are dealt with preponderance of the evidence standard. And so treble damages should be no different from the other ones, and we should make it consistent among damage issues. So the effect was that this harmonized the analysis of attorney's fees, treble damages, allowing the district court broad discretion in determining when to award enhanced damages for willful infringement. The Apple-Samsung case, and there's been a lot of Apple-Samsung cases, but this one is well known these days. Apple sued Samsung for infringement of numerous design patents. in their smartphones. And the district court found infringement and awarded over $1 billion in damages. Samsung appealed and argued that the district court erred in awarding those damages, as they said that the design patents were to very specific elements and that the profits that they were awarded were to the phones in their entirety, and that those should be apportioned based on the infringing elements and not the entirety of the phones. The Supreme Court granted certiorari in March, and so we'll see that coming up to the Supreme Court. At the Federal Circuit, the issue is whether a design patent infringement award should be limited to those profits attributable to the component of the product the patent applied to. And the Federal Circuit took a very literal approach to reading Section 289 and said that it was clear and that it authorized the award of total profit from the infringing product. The argument being there that if these elements are all contributing to it, they're all part of the product, and the product is sold, that's what the actual profit is. It's the product itself, not a percentage of a component. And so we'll see what the Supreme Court's going to do with it. The Supreme Court, there were two issues appealed, or two questions appealed to the Supreme Court. Where a design patent includes unprotected non-ornamental features, should a district court be required to limit that patent to its protected ornamental scope? And where a design patent is applied to only a component of a product, should an award of infringer's profits be limited to those attributable to that component? And the Supreme Court only granted cert as to question 2, and they did that in March. So we'll see what they say about that. On to the Patent and Trial Appeal Board. Cuozo is the first IPR case, and so there's been a lot of discussion of Cuozo. But there's a couple, it went up to the United States Supreme Court, and there's a couple points that are pretty important from Cuozo that came down this year. So we'll look through here. It has to do with Garmin and GPS technology. Obviously, Lee is the director of the United States Patent and Trademark Office. They're being represented regarding Patent and Trademark Office procedure during this appeal. And Garmin challenged the validity of Cuozo's patent under obviousness during the IPR, and the PTAB applied the broadest reasonable interpretation standard, which for those of you practicing in patent law or who work in ancillary areas, that's the standard that they apply at the patent office. It's not the standard that's applied at district court level on a litigation, but at the patent office. And so the concern is that there's two different standards going on for claim construction that can be occurring in parallel time in certain instances. One is the BRI standard, which is, like I said, applied at the administrative level at the PTO. And then the other is the standard that came from Phillips versus AWH, which is the meaning that a term would have to a person of ordinary skill in the art in question at the time of the invention, which is a slightly narrower scope because it's not the broadest reasonable scope, right? And so the first issue was whether the PTAB in the IPR proceedings may use the BRI standard rather than the plain and ordinary meaning as understood by one skilled in the art, as set forth in Phillips, and whether the PTAB's decision to institute an IPR proceeding is judicially unreviewable, even where the board exceeds its statutory authority. So those are the two issues that went up to the Supreme Court. And with respect to the first issue, the Supreme Court unanimously affirmed the use of the BRI standard, holding that the BRI standard is based on administrative deference and a policy argument that the BRI provides stronger bounds on patent scope. And I'll note that this is an area that there's been a lot of discussion, and saw the chief judge of the PTAB, the former chief judge of the PTAB, James Smith, speak on this issue earlier this year, and he said that really there's going to be two standards applied somewhere. Either it's being applied in the court and at the patent office, or it's being applied by the patent office and the ALJs there, just with respect to office actions or applications that are currently pending before the appeal board, the PTAB, or things that have issued. And so there's some arguments on both sides. And then something else that has been reiterated a lot through these arguments by the patent office is that there is the ability to amend claims, and wherever there's the ability to amend claims, we should have the broadest reasonable interpretation. Now, some people will say that in an IPR, because there's been so few amendments, it's really, while you can make amendments, it's impractical, because it's only happened in, I think, in a handful of cases. I think less than 10 cases at this point. I think earlier this year was somewhere around maybe 7 cases that actually successfully had an amendment. And in an IPR, it is difficult to amend because not only are you offering this amendment, you got to have your support through the specification, but that amendment has to result in the claims having patentable weight. So the PTAB doesn't allow you to amend the claims if they're going to invalidate the claims under the current obviousness or novelty rejection that's at issue in an IPR. And so that's part of the difficulty, is that a lot of the cases where people are trying to amend is they already know they've got a fatal issue with their claims and they're trying to overcome it. And in many instances, the PTAB at least is saying that even with that amendment, you wouldn't overcome the rejection and the claims are invalid. And then the Supreme Court issued that an IPR, or the PTAB's decision to institute an IPR, is not appealable, is final and not appealable. And I think what I'll do right now, because I'm running a little bit out of time here, I think I've got about 5 minutes left, is maybe pause here for any questions and answers. And I apologize that we didn't get through everything. I had a couple more cases to go over with you, but I will provide a copy of the slides and then also a handout with a little bit more detailed analysis so you can see those. And like I said before, I'll go back here to the end of the presentation. You can contact me, reach out to me. I'm more than happy to answer any questions or have any discussions that you may want to have regarding any of the cases, including the ones that I didn't get to. So, all right, I'll leave it open for Jason to provide any questions we may have.
Thank you a lot, Jonathan. That was a very good presentation. I have one question now, and I'll just stop now to remind everybody, if you have any questions that you'd like me to ask Jonathan, please send them to me. You can use the questions box on the side of your panel or also use the chat feature. So while we're waiting on some other questions, I have one question in particular. And this goes back to one of the first cases you mentioned, rapid litigation management. And in that case, you said the court held that a patent directed to a law of nature is not automatically invalid. And this case follows another case from the Federal Circuit back in May called Infish v. Microsoft, in which the Federal Circuit also held that improvements to computer-related technology or software are not automatically abstract. So my question to you is, does this hint to any changes that might be occurring at the Federal Circuit about backtracking on where the patent eligibility cases have gone so far, or is this just kind of a blip and we're going to continue seeing more invalid patents?
I do think that the Federal Circuit is trying to kind of maybe put some boundaries and some bookends on it, and I think that's oftentimes even clear when you just read, a lot of the cases that come down between the Federal Circuit and the Supreme Court, and some of the frustration sometimes by the Federal Circuit judges. I'm trying to remember which case it was. There was one of these cases on patent eligibility that it might have been the rapid litigation management, where there was a concurrence actually, and actually no, it wasn't rapid litigation, because it was a case where they found that the claims were, well, anyway, it might have been that, but the concurrence actually said, it went through this whole thing about the inventiveness of this claimed invention, and said that under any old standard, these claims clearly would have been patentable, essentially, but only because they're strictly applying the test provided by the Supreme Court in Mayo and Alice, the claims are invalid. And so you can see that tension, and I think there's a couple of things going on here with the Enfish case and also with rapid litigation management. And even to a certain extent with some of the other cases we talked about, where they talked about like a term of degree for indefiniteness, is trying to make sure that these holdings, which are based on very specific facts, very specific claim language, should not be considered sweeping and broadly applying to everything. While at the patent office, 101 rejections are oftentimes very sweeping right now and being applied to everything, at least in certain art areas. The court's trying to say, keep in mind, this isn't like a be-all, end-all, all terms of degree are indefinite, or all patents related to computer technology or software technology are indefinite. And I think some of that is possibly a message to go back to the patent office, because examiners have been taking a very strong approach, and maybe this is giving something patent practitioners can use as a tool to come back and say, whoa, 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 the Supreme Court or the Federal Circuit has clearly stated that simply because this is related to software or computer implemented technology, it does not mean that it's indefinite. Just because it relates to an abstract idea or to a law of nature, is directed to one, embodies it in the claims to a certain extent, does not mean that it is per se patent ineligible. We do need to apply the test. And I think that part of it too is that the Federal Circuit is dealing with a lot of the aftermath of these cases, where you have one, you have appeals coming from the Patent Office itself on rejections. Two, you've got IPRs that are coming up to them, or there's been fewer post-grant reviews, but generally post-grant challenges to patents that are coming before the Federal Circuit. And then they're also dealing with all the cases in litigation that are coming up. And so they're dealing with these on a daily basis, all of these cases. And I think that if they can put some bookends on it and try to build some boundaries, and they want to do that to help the people in practice and to put some clear boundaries. But the question is whether the Supreme Court will pick up any of these and say, well, no, you need to strictly apply our test and not create the bright line rules. Thank you for the question, Jason. Are there any other questions, or we might be about out of time?
Yeah, I'm not seeing any, and I think I'll just add one other question. What kind of advice are you giving clients who are coming in with inventions that might not be patentable under the current patent eligibility standard? Do you see any hope for improvement going down the road, or are you telling the clients that under, too bad, so sad? What kind of advice are you providing?
In the area of, I'm in the life sciences area, less than the software computer area. I still think that there's ways that we can craft claims to a lot of inventions and try to get them in a position for allowance. Obviously, it's difficult right now, and so one thing is being very candid with clients regarding the difficulties we're facing, so that they're aware of it and they're prepared for that in case it does an issue, or for a longer, harder prosecution avenue. And part of that too, though, is counseling them on that when we're building an application or writing an application, and dealing with them from that perspective to say, what can we add in here to move beyond? How can we look at the Mayo test and say, okay, let's embrace the fact that we have something that's directed to a law of nature or an abstract idea, but at the same time, let's try to see how we can satisfy the second part of the test, or get out from under the second part of the test, where we're offering more than novel, routine, conventional methods. And part of that is maybe building in language into the specification, describing the invention in a different way. In some ways you tell a story of non-obviousness in your specification, where sometimes you think about the end result, if your patent's ever before a jury, telling a story about the invention so that they can understand it and kind of grasp what happened. In this instance, we kind of want to maybe now tell a story of why the second part of the Mayo test isn't fatal to the invention. And then the other thing I tell them is just, we're early. These cases just came down, and they're wading through right now. They're going through district court litigation. They're going through IPRs. They're going to the Federal Circuit, and some of them are going back up to the Supreme Court. And over time, we're going to have a clearer picture of what's going on. So hold out a little bit of hope with that. But yeah, thank you for the question again. And thank you for letting me give the presentation. I really enjoyed preparing for it. So hope it was informational for everyone.